Hello everyone, this is Cheenu Sharma. So welcome back to another important session. So today for the NCA Professional Responsibility Examination, we are going to cover the latest sample paper that is there on the NCA website, as well as I'll be giving you brief on 100 marks sample paper, which includes 5 questions, hypothetical questions prepared by me for practice. So we will be discussing that, but for that I won't be going into much detail because you have to attempt those questions and send back to me. So this is just for a help, but for sample paper, we are going to do detailed discussion. Now let's begin. So now let's start with our first question for NCA latest solved sample paper. So question 1, 30% of exam grade. It means this is long question, 30 marks question, and examiner is expected from you 54 minutes to give to this question, including the reading time. So let's see what's the issue in this question. So Suzanne Smith, a longtime friend of yours, is the executive director of non-profit organization Youth at Risk that support young people who are at risk of getting in trouble with law. During this friendship, Suzanne occasionally asked for pro bono legal advice. Pro bono means free legal advice on matters related to her non-profit organization's lease of its office. Recently, you have undertaken to negotiate the terms of a termination of an employee from her organization only, YAR's financial assistant, and that termination was done by your friend Suzanne. This negotiation has just commenced. You are asked to attend a meeting of board of director to report on this negotiation. At board meeting, Frederica, the assistant director, asked to speak with you in private. You and Flint leave the board meeting and she draws you into the hallway just outside women's washroom. She tells you that she has information that Suzanne has been skimming money from youth at risk for her own benefit. So Suzanne means your friend. And here Flint is the person that is from that organization. So she is the assistant director. She hands over to you copies of bank record that show a pattern of $1,000 withdrawal each month from bank account payable to Suzanne. She advised that the real reason Suzanne fired that particular person for which you are negotiating is that she had discovered that your friend Suzanne has been stealing YAR bank account. You advise Frederica that you will think about it and get back to her. Just as you end this conversation, Suzanne exits the women washroom. You arrange a meeting with Suzanne the following day. You confront her about the allegations put forth by Frederica Flint. She responds by saying that Frederica Flint is after her job. She wants to take her position as executive director, because here you saw that Frederica is, it's mentioned right here, assistant director. And it was Flint who told you about this. She asked and you confirm it that there is absolutely no relationship between firing and allegations made. She continues, look, you have been my lawyer here ever since I started work and nothing untoward has ever occurred here. She asked to see the bank records that Flint gave you and you show them to her. She responds by saying that the withdrawal have nothing to do with anything improper. So see, you are a lawyer. You have interest in the matter. You have clients from your friend's organization. And here your client's case is affected by your friend's presence in the organization. So if you are showing her something, it means you are not justifying your position as a lawyer. Because here, by showing the accounts, the bank details that Frederica has shown you to your friend Suzanne, you are bringing your personal interest to the matter. You are bringing your personal relations. She asked to see the bank record that, and you showed them. So see, this is the main issue. She responds by saying that the withdrawal have nothing to do with her. Basically, she's justifying her position. In fact, she says she has a copy of that agreement with her and shows it to you. The agreement is signed by Suzanne and the chair of board of director, which entitles her to pay herself $1,000. So she is saying that the $1,000 per month that she's getting is the compensation that she hasn't taken any leave for vacation for about 3 years. So then a few days later, you call Frederica Flint to tell her about special agreement regarding vacation pay and that there was an innocent explanation on part of your friend Suzanne. Within minutes, you receive a phone call from the chair of the board of director. He informs you that no uncertain terms that was never an agreement to pay Suzanne. So the board of directors chairman himself calls you and tells you that there was no such agreement and that Suzanne has taken the full amount of her vacation each year, and whatever she is saying, that is not right. He asks you why you were talking about all this with your friend Suzanne. So he questions you, the chair board of director, he questions you that why you discussed everything that someone has told you about your friend to her, only to learn that she has left town. Then you immediately got to know that Suzanne has left the town, abandoned her apartment. She made one last visit to bank and withdraw $30,000 from the organization's bank account, and she has not been seen since. So see, here Suzanne was at fault, but more than Suzanne, as a lawyer, you are at fault because at every step you brought your friendship into picture. So you gave preference to your friendship than your professional responsibility. So as you reflect on these turn of events, you begin to wonder whether you have not handled this properly. What were your responsibilities? What mistakes you have made? What may be the consequences? So here the issues are whether you as an attorney providing pro bono legal advice to youth at risk acted properly in handling allegations against executive director Suzanne Smith. Second question is, in acting all these things in this whole event, what were the ethical violations or legal responsibilities that were being breached by you? So for this, number one, the very first thing that comes into picture is conflict of interest. So you are already representing someone, your client, and that client's case has something to be affected by Suzanne's presence. So avoidance of conflict of interest, then the commentary related to it, which talks about importance of avoiding it, nature of conflict. Then Suzanne's legal advisor, there is a duty to maintain confidentiality regarding information shared by Suzanne unless there is an exemption. So you being Suzanne's legal advisor, you cannot discuss anything and everything with other person, not even with like Frederica Flint or with board of directors chair. So there is a confidentiality. Then when presented with information by Flint, it was your responsibility firstly to investigate the truth. So duty to investigate thoroughly to ascertain whether there is something truthful in the statement made by Suzanne or not. So rule 5.1, then there is a duty to remain loyal to client's interest. So loyalty. So these four rules you have to apply in your analysis. So you have to relate these with the facts. Like rule 3.3, sensitive information not shared without proper authorization. Frederica Flint approached you with sensitive information regarding the bank accounts, that there had been a withdrawal of money like $1,000 every month. So you don't need to show those things to Suzanne without verification, without discussing with the board. So that basically have compromised the investigation integrity. Then, by discussing Flint's allegation, bank records with Suzanne, again there was a duty of confidentiality to the organization as well, on behalf of whom you were acting as a legal advisor. Then you had duty to maintain client confidence. Again, there are few cases that you have to mention in between, like McDonald Estate versus Martin. This case beautifully talks about a lawyer's duty to have confidential information intact, not to share with anyone, not to do any misuse. Then, with regard to second issue, duty of loyalty comes into picture. This is the most important thing. Then client interest, conflict of interest. For this we have R versus Neil case. Further, we have Strother case in which conflict of interest comes into picture. Then from R versus Neil, a bright line rule comes, like where lawyers are prohibited from representing client with directly adverse interest, like in this case without explicit consent. So these are the things that you have to bring into picture in your analysis. Then you have to conclude briefly. So that's how you are going to attempt question. Next is again 30 marks question, 54 minutes. Robert Katze is an inventor. He has invented many things. So there something related to invention. Sadly, he never seemed able to get them to patent, but whatever he invented, he was not able to get those items patented on his name. As a result, he continues to live with his mother and toil in her office or garage. Katse, who is a recreational curler with a long-time fondness for the quintessentially Canadian sport of curling, has spent years developing a sophisticated system. So he has prepared a sophisticated system. He recently concluded that invention was complete and ready to be introduced to the world. He described this idea to his curling team, one of whom, Cal Cavendish, a lawyer, listened with interest but said little about it. So there was a lawyer in his team, Cal Cavendish, who listened to his idea, but he did not say anything much. It turns out that Cal Cavendish does legal work for another organization, Sports Broadcaster, a television network that broadcasts curling throughout Canada. So he immediately shared these benefits of his client's invention to them, and the very next day informed them of the idea. So this thing was unknown to Katse. So Katse's ideas were being shared with another company by his own lawyer. Katse met with lawyer Bob Byrne the following week. Bob proposed that they go into the project together, with Burns providing the legal advice, Katse providing the idea, Katse's mother providing the money. The three met and agreed to establish a company, Katse Curling Concept Limited, with each taking one-third interest. Byrne immediately applied to have Katse's idea patented. It wasn't long before the Katses, on a return visit to Bob's office, learned two things. Firstly, Cavendish has shared the idea with TSB. On behalf of TSB, Cavendish has also applied to have idea patented. Already the idea that was put into forth by CATSE for patent registration was already in the process of getting registration by Cavendish on behalf of TSP company. Secondly, throughout the time when they had been meeting with Bob, his small two-person law firm had been negotiating to join Cal Cavendish, somewhat larger firm, had days earlier joined then larger firm. So Burns told Katse that as a new member of the Cal Cavendish firm, he was happy to continue to pursue Katse curling concept on their behalf. Also added that if they are not prepared to continue to have Burns represent them, pursuant to terms of agreement, the Katse will be required to buy out his share for their initial value, a value that corresponded with value of legal work he had permitted in setting. So the Bob Byrne, the lawyer himself, has joined during this agreement going on Cal Cavendish firm, so another larger firm. Katse, especially Robert, are upset. What they thought was going to be a wonderful venture, a contribution to the curling world, and possibly a lucrative company, but seem to have blown up on their faces. They have now come to you for advice regarding their treatment at the hands of Cavendish and Byrne. Assume for the purpose of this question that Katse curling concept is patentable, has been patented by the other company TSB, and it was initially your idea. So what advice you would provide them? What are the courses of action? See here the wording. If it's mentioned courses of action, then you have to bring this into your conclusion as well and as one of your issue. So first is whether Cal Cavendish breached any legal ethical duty by disclosing Robert Katze's idea to other company. Second is whether Bob Byrne acted properly in continuing to represent Katze Curling Concept Limited after joining another lawyer's firm. And then he was demanding buyout of his share. See here, firstly, financial interest is there, then representation, conflict of interest, confidentiality, duty of loyalty, all those things comes into picture. So fiduciary relationship, the relationship of trust with your client. So first rule is fiduciary relationship, duty of loyalty. Model Code 3.4 talks about this. You have a duty as a lawyer to not act for a client where there is a conflict of interest. Then duty of confidentiality, secrecy. If your client has shared some idea with you, you are not, as a lawyer, expected to share that with some other person just for the sake of financial interest. Then handling conflict of interest. You can refuse to act, withdraw from representation, or if you want to continue, you should have expressed consent from the client. So these are the important rules that you have to analyze. So for first, you have to use these fiduciary relationship, duty of loyalty, confidentiality. Then we have case of Stewart versus Canadian Broadcasting Corporation, almost similar kind of case. Then second issue that needs to be analyzed is the Bob Burns conflict. So here also significant conflict of interest, as he was already being a part of a firm and then going to another firm against whom already there was a case by your client. So Law Society of Upper Canada versus Caminer, this is the case, and in this case directly personal financial interests were involved, were part of conflict of interest. This case directly resonates with the facts of the question we have. Then what are the courses of action? Either CATSE can file complaint about both Cavendish and Burn to the Law Society because both have failed as lawyers at different steps. You can seek legal recourse for breach of fiduciary duty. Then you can initiate lawsuit and ask for damages. Then terminate the representation, seek new counsel. So these are the three basic courses of action that are available to you. Then you can conclude your answer. Okay, so the third question here is 15 marks question, 27 minutes. So you have two options, part A, part B. You can attempt either part A question or part B. So these kind of questions are good. Options are always good. You can attempt the answer that you think you are 100% sure about. So here, based upon chapter 1 course material, directly they are asking you. Here they are not asking you to solve any issue. You just have to provide examples on basis of lawyers' ethics from the perspective of loyalty, justice, integrity. That you have to here create hypothetical examples based on loyalty, that where your loyalty could come into picture as a lawyer, where justice has been expected from you as a lawyer, integrity could come into question. Then you have to tell with specific example how as a lawyer you would encounter with these things. So three such example explain why lawyers approach corresponded with perspective you associate with, and examples should address at least two of the three perspective. So they are asking not to attempt all three, just any two, but here for your help I have solved all these three issues. So based on chapter 1 course material, we are exploring ethics of lawyer through the lens of loyalty, justice, integrity. So rule 2.1, this rule directly talks about these three things. So that is why we are just here using one rule that is encompassing all these three important attributes that are there under lawyer's professional responsibility. So for loyalty, consider a scenario where a lawyer is representing a client who has confessed that he has committed a particular crime. So as a lawyer, even if you are aware of client's guilt, you have to vigorously, zealously defend them in court, ensuring that they receive a fair trial, advocate for best possible outcome. This aligns with the perspective of loyalty because lawyer is faithfully representing the interest of their client despite personal knowledge of their wrongdoing. So in this case, loyalty means prioritizing client interests, upholding their rights within legal system regardless of personal judgment. Then justice. Imagine a case where a lawyer is handling a civil suit on behalf of a group of individuals that have been discriminated by a company. Lawyer not only seek compensation for victim but also works to hold company accountable for such practices. This exemplifies perspective of justice because lawyer here is striving to ensure fairness, equity by redressing to those who have been wronged. By pursuing justice, lawyer is acting as an advocate of societal values and rule of law. For integrity, a lawyer discovered that a piece of evidence crucial to their case was obtained unlawfully. Instead of using it to bolster argument, lawyer informs the court of its questionable origin and chooses not to present. So, rightful disclosure of evidence that we have discussed towards the end of our lectures. So, this is one of important ethical standard. To sum up, in each of these examples, the lawyer's behavior aligned with a particular perspective, loyalty, justice, integrity. Then to make your analysis better, you can mention any one case that is encompassing all these values. So for that, we have a beautiful case of R versus Neil that talks about integrity, then loyalty and all those things. So part B question is a small essay type question. They are directly asking you to give your views on role morality. As a lawyer, how your moral role comes into picture. What observations would you make about this question? What concerns you think have with the issue of morality? So for this, when they're asking your opinion, you have to use work of different scholars that we have discussed under our various topic. So firstly, explain role morality topic. So role morality means questions about ethical behavior of lawyer and public perception of their profession. What public expects from you and what as a lawyer you have to do. So there should be a balance between your moral standards and your legal profession. So this is role morality. Then observations, sometimes there are conflict of standards. Then public trust could be eroded sometime by role morality. Then ethical dilemmas at every step you will face as an individual also conflicting interest between your professional obligations and your ethical values. So you have to bring those things into a balanced manner. Concerns about role morality. So role morality, every time you cannot expect the lawyer to be ethically correct. So, role morality can compromise a lawyer's moral agency, making it difficult to act. Then there could be impact on justice as well sometimes. Justification of role morality. So, professional obligations. Lawyers operate within a complex framework of law, regulation, ethical obligation that often require them to navigate conflicting interest and responsibility. Then, adversarial nature of legal system necessitate lawyer to act zealously, which may require actions that are uncomfortable on a personal moral level. So, role morality means that when you have to justify your actions based on your professional obligation as well as moral obligation. So, that is role morality. So, when a lawyer beautifully balance this thing, then the implication is on justice system is that there is a perception of fairness, professional integrity comes into picture, moral compass of a lawyer. So moral compass means as a lawyer, what are your moral beliefs that you want to take with you during your professional duties? So for this, continuous ethical training is required, personal professional morality, there has to be reconciliation between both. And to make this answer better, we have to follow few important cases and article. For this, one is David Luban's adversary system excuse. Elise Woolley's perspective, we have discussed all these things in our lectures. William Simon's view on justice, R versus Murray, one of the most important case that talks about ethical dilemma. Then you can conclude this answer. So in professional responsibility, you have to keep this thing in mind that sometimes questions could be answered without IRAC format. Also, there is no harm to such thing, especially the shorter ones. But like this case, it all depends how smartly you attempt an answer. So in this case, they have directly asked implications of a Supreme Court judgment, and they have then further asked additional questions. So here you can use IRAC method to explain this case and then to answer further questions which talks about in what ways does it create implication for lawyers, and how effectively it has introduced new concept, new issues, this case basically. So for that you can answer simply in paragraph form, but for this case you can use IRAC method that like I have mentioned here. Firstly, tell what this case talks about. So this case central issue is client-client conflict of interest. So you have to firstly mention in introduction what this case is all about, then go with the issues in this case, what was the main issue, then rules, application, and then here you can give a brief conclusion, what was brought forward by Supreme Court of Canada under this case. Then you can start answering as per the further questions. So how this case correspond with the existing law, like the existing laws concerning conflict of interest, lawyer's duty, candor of the client. So this case reinforces with all these principles. Then there are new issues, concepts that came forth, like timing of disclosure, remedies for breach, implication of multi-client law firm. So these were the new things that came from this case. Then what are the consequences for lawyer and legal obligation? So this case necessitated more heightened ethical awareness on part of lawyer legal profession. Then law firms need to strengthen their conflict screening processes, risk management, legal practice dynamics has to be established. So then you can conclude. Then we have short question, 18 minutes, 10 marks question, in which they have directly asked you about simple opinion for access to justice. But here the issue is you have to check the wording of question. So it's kind of a criticism, two views. Some people argue that problem of access to justice is one that lawyers are uniquely obligated. Identify the way in which you agree or disagree. So identify the ways means you have two issues. Firstly, to see how access to justice is an agreement with barriers. Then you have to disagree with barriers to access to justice. So there are two views. So issue is what are the barriers to access to justice and who should be responsible for addressing them. So then you have to follow the rules, model code of conduct rule. Firstly, whenever you're getting a question on access to justice, try to explain, give meaning, definition in 2-3 lines. Then analysis. Firstly, you have to give your viewpoint, agreement with barriers to access of justice. This says that you are agreeing that there are few hurdles, there are few issues to access to justice. So under this you can mention cases and you can give these kind of headings. Then how to address these barriers as asked by question. So several key steps that we have discussed. Again, you can conclude these steps by a case. Then you have to give second issue. The other second issue means from the very first issue only, one issue only, you can give second heading, disagreement. So this would be like a debate. Disagreement with the absence of barrier, that there are no barriers to access of justice, it is freely available. So here you have to see mention how you can say that. So there are few studies, there are few opinions, as I mentioned you when we were discussing this topic, that this person is saying that access to justice is freely available to people. This person, this scholar is saying that it is difficult to have access to justice under Canadian justice system. So you can use those viewpoints and from those articles you can make your answer in these kind of pointer forms. Rest you can get these. I will send you the PDF of all the solved questions so you can get those PDFs printed and that would also help you in examination. But remember, you have to paraphrase and then write. Do not copy paste anything. So then you can conclude. So this was the sample paper. So next, the hypothetical self-prepared questions by me for IRAC practice. So you have to attempt this question and send back to me. So I can just give you an idea here that what this question is about so that it will be easier for you to attempt. So in the very first question, the main issues are related to disclosure of confidential information like we did in our sample paper, one of the question. Then you have to talk about client-client conflict of interest, concurrent representation when you are representing two people to opposing party at the same time, how it constitutes breach of professional responsibility. So under this, the rules: client confidentiality, conflict of interest, informed consent, then withdrawal. So these are the rules that you have to follow, and this is how you have to give your analysis. So see, the way I have highlighted things, the way I have shown different headings in examination, it's always suggested to follow this. And this you can only do if you have practice, if your typing speed is good, only then you can go to this decoration. Otherwise, it would be difficult for you to just attempt answer in simpler manner. But I always prefer attempting like this because it keeps a good impression on the answer writing checker. Because the person knows that you are not in a hurry, you are actually wanting to pass this examination and you are giving your best as you can. So this is how you go to attempt. Like, always try to italicize your issues, then highlight main things. Like, always cases to be in italics, main things, rules should be bold, underline, issue, rule, application, analysis and conclusion, suggestion, whatever is there. Then always in your, when you are writing 2-3 paragraphs together, it's difficult for checker to follow the things. So highlight main issue from where you are going to start analyzing it, the rules in between, then the cases, like this. Then like here we are analyzing second issue, then the rules, conclusion. Then the very second question. So here again, question is related to representation by a lawyer. So communication of information to client in a clear and understandable manner. Then there is a conflict of interest duty again. Then there is a duty to make your legal services available to public efficiently, conveniently. If someone is not able to pay fees, then you cannot take advantage of a person, or if you think that someone is only relying on you for legal representation, you cannot ask them for unnecessarily higher fees. So these are the things that comes under rule 4.1. So you have to mention that you have to take every case with complete diligence, show your competency. Then you have a litigation conduct, conflict of interest, communication with client. Then you can mention cases that are related to the facts of the case and conclude. Then third question. In this, there were again unprofessional conduct, ethical breaches. The question was about negligence on part of a lawyer. Then again, here issue was related to communication to the client. Then make client understand information provided to them. Language issue, this we already discussed in our lectures in detail. So language issue was there. Then knowingly misleading or allowing a client to mislead a court, you have to prohibit this thing. You cannot force someone to plead guilty. We also have discussed this thing. You have to be honest and candid with your client. Then you have to emphasize the importance that your client should know, that they understand the relevant factors and then they take a decision. So under this, we discussed guilty plea and all those things. Then there's a duty of care on part of a lawyer, then standard of care, then causation and damages. Then you can conclude. So there is a short question. This is related to basically simple analyzation of access to justice. So here there was a lady, Lisa, single mother, 2 minimum wages job. She was terminated from one of her job and was facing eviction from her apartment. She cannot afford to hire a lawyer. She reached out to several law firms, but all quoted fees far beyond her means. So Lisa heard about a new initiative of paralegals and also she's unsure if they can handle both employment and housing matter. Meanwhile, a local bar association is debating whether lawyers should be required to perform minimum amount of pro bono work. So here the issue is related to access to justice. Then what are the options that could be accessed by Lisa? So the issue involves analyzing access to justice problems highlighted by Lisa's inability to afford legal representation. You have to mention the rules, the commentary that is related to this. Then you have to analyze her situation. Based upon her situation, you have to see what are the barriers based on her case to access to justice. In our sample question, we discuss simple general barriers. Here we are discussing the barriers that are related to Lisa's case. And for that, like we are referring to cases as well in between. And to finally analyze, we have to see what are the solutions available to her. Then we can give her further recommendations, what she can do, or we can also give recommendation to local bar associations, like they can implement mandatory compulsory pro bono requirements. See, the question in which they are asking your opinion, your suggestion, they are not going to judge you on the basis of right or wrong. Does not matter whether the answer writing checker has completely opposite view than yours. You just have to give full reasoning, full justification for whatever viewpoint you hold. So this is how you're going to attempt. So I have tried to inculcate every different kind of question, short, long, IRAC, simple essay format, so that you can attempt all these questions and you have good holding on answer writing. So that was all about our course for NCA Professional Responsibility Examination. I'm sure you will definitely gonna do well in exam. So feel free to reach out if you have any other queries, and also do send your attempted answers on this email. Follow the Instagram page, Juris Journey, NCA Triumph and Canadian Law. Keep supporting. Thank you and all the best for your examination.